Matt Christensen. I am managing partner here at Inksman Johnson. This is one of a series of classes that we're teaching related to COVID-19 crisis and various different legal aspects of that. We have several attorneys from our office who have been presenting these, and I hope they're useful to some folks and that people are sharing them, sending them to your friends, neighbors, other business people that you know, that sort of thing. We are trying to ensure that the information stays as up to date as possible and that we're helping people answer some questions. I do have to include a disclaimer at the beginning that we are not creating an attorney-client relationship with anybody just because you view the video. We're trying to provide the most up-to-date and correct information, but it's not necessarily legal advice that you should rely on. If you do have a specific issue, get some advice about that specific issue. But we do hope that these are useful, that it is answering some general questions, and that people are able to understand things in the world the way it currently is working in a little bit more applicable manner and with your eyes wide open, essentially. We do, like I said, already have a library of these videos that we've created. They're all available on various social media platforms, have links. They're on the YouTube channel for the firm. Usually takes a day or two to get posted after the presentation actually occurs. But we've done ones in the past on landlord and tenant law issues. There's an excellent tax law portion from Nathan Fowler, our attorney in Twin Falls. We also have done some estate planning, employment law issues, previous small business ones from myself. We do have several more planned. So coming up in the next couple of weeks, there will be one dealing with family law issues in general. So divorces, child custody issues, child support issues that have come up. We'll kind of continue the small business topic by talking about some top 10 tips for coming out of the crisis, recovery tactics for your business. We will have one on internet security, as people are using the internet and the web for communications, for client sales, this sort of thing. The different topics come up with internet security, and then additional ones specific to the agriculture industry, so farmers, ranchers, dairymen will want to chime in for that. Today's topic is bankruptcy and the stimulus bills, bankruptcy and the COVID-19 situation, and in some cases just bankruptcy in general. Bankruptcy is my practice area. This is what I've done for the last 15 or so years. We have a team of attorneys here that focus on bankruptcy issues. And there are some aspects that are unique to this COVID-19 situation, and we'll get into those. I want to start out just with a general discussion of what bankruptcy is, potentially what it isn't, things to be aware of as far as different types of bankruptcy. And some of it depends on if you're an individual filing a bankruptcy case or a business filing a bankruptcy case. Individuals have 3 or potentially 4 options when you're filing a bankruptcy. Chapter 7, which is a straight liquidation. Chapter 13, which is a reorganization. You're a wage earner. You have a regular income that you can use to repay your creditors. And then Chapter 11 and Chapter 12. Chapter 11 for an individual is similar to a Chapter 13. It's just more robust and a bigger case, a larger amount of debts generally. Chapter 12 bankruptcy is for farmers and fishermen. You don't see a lot of fishermen here in Idaho, but family farmers who depend on farm income, you'll typically see Chapter 12s here in Idaho. There's a last type of bankruptcy, which is probably the most rare. We've had 1 or 2 cases like this here in Idaho in the past, and that's a municipality bankruptcy, so a city or a county. There is some projections that I've seen that indicate not necessarily here in Idaho, but nationwide, we may see some increases in municipality bankruptcies as municipalities have had to lay off employees and that sort of thing. So we'll see if that touches us here in Idaho. Businesses, on the other hand, are generally limited to Chapter 7, straight liquidation, or Chapter 11, which is a reorganization, can be a liquidation as well for a business. And then Chapter 12 as well for businesses that are family farmers, so family-owned business that does farming. Most of the general outline and general process that I'm going to talk about will apply to Chapter 11 and Chapter 12 business cases more than a Chapter 7 or a Chapter 13. Chapter 7 case, the business files the case, the individual files the case. There's a Chapter 7 trustee who is appointed. His or her job is to liquidate everything that can be liquidated, recover certain payments in some circumstances, and then use those funds to pay creditors. At the end of the day, the debts to those creditors are discharged for individuals, not for businesses. And then the individual moves on, the business isn't operating. So Chapter 11 is a reorganization for that business. And I think that's one of the biggest misconceptions to get over, or hurdles to get over. A business that files Chapter 11 is not just throwing in the towel and saying, I'm done. That's a business that files a Chapter 7. Chapter 11 for businesses are reorganizations. Those reorganizations may include a liquidation of some things, may include termination of certain leases, may include a liquidation of the entire business, but you're trying to liquidate it as a going concern business that then retains that value as a performing business rather than as a liquidation sale, and we're not going out of business type sale. So it is a reorganization. Same thing with Chapter 12. That's a reorganization of the farming operation. It's not a straight liquidation of everything and we're just fire selling it and getting the cheapest price we can. So I think there's some stigma that goes along with filing bankruptcy for your business, and it needs to be looked at as a tool. It's one of the options to keep your business going and allow you to reorganize some of those debts. A couple of bankruptcy terms: automatic stay. As soon as that business is filed, or if that bankruptcy is filed, the automatic stay kicks into place. There's nothing that has to happen other than the bankruptcy petition is filed for that stay to kick in. That's the automatic part of it. Once the stay kicks in, then that will halt creditor activities to collect assets, to collect funds, and give the debtor a little bit of breathing room to move towards getting a plan confirmed. The debtor at that point is known as a debtor in possession, which means the debtor basically wears two hats. You are the debtor, the one that owes all the funds to the creditors, but as a debtor in possession, you're also acting as a trustee for those creditors. So you have duties to those same creditors that you also owe funds to. In a business context, when the business files a Chapter 11 case, the easiest way to sort of conceptualize how it works is that business now has a new partner. Partner in the business is the bankruptcy court, and the bankruptcy court wants to know what's going on with that business. So there's regular reporting that has to occur. There's approval that you have to get from the court for certain things that are outside the ordinary course of that business. There, in some cases, may be a trustee that's appointed or a creditors committee that's appointed, which also serve important roles and act as partners in that business as well. In a Chapter 11 context, there's also what's known as a small business case. So a business that up until a couple of weeks ago had 2.7-ish million or so in debts could qualify as a small business debtor, and there was a much more streamlined process for that debtor to then proceed through the bankruptcy. One of the stimulus bill provisions that was in the CARES Act that did get passed by Congress and signed just at the end of March was an expansion of that debt limit. So instead of 2.7 million in debt, a small business debtor could have up to 7.5 million in debts and still qualify as a small business debtor that has significantly more streamlined provisions for getting a bankruptcy plan confirmed. And in a subchapter 5 small business case, which is what that limit applies to, there's a Chapter 11 trustee that's appointed whose job is to assist in getting a plan confirmed. So it's an additional advocate on behalf of the debtor in that case. In working with those creditors. The whole point of a Chapter 11 and 12 case is to get a plan confirmed. We're trying to move forward. You're trying to reorganize the debts, and the plan is how you tell the court you're going to reorganize your debts. That plan is proposed generally by the debtor, and then creditors have certain rights to object or otherwise get some of the terms changed. So that's sort of bankruptcy in general. I want to move now to some of the impact of the recent bills on bankruptcy cases. So there's been several stimulus bills that come into play. There's also programs that were already in place to assist small businesses through the SBA. So the CARES Act, which again was passed at the end of March, there are several different provisions to that act, one of which is payment protection loans, PPP loans. Those loans are available for debtors, debtor companies. They're available for companies to receive and then file a bankruptcy petition if you need to. There aren't restrictions on the PPP loans and whether you have to be or cannot be a bankruptcy debtor in order to receive those loans. Additionally, like I mentioned, the expansion of debt limits for small business, subchapter 5 small business debtors was expanded to 7.5 million, which really opens the door for some businesses to get in that streamlined process. I think since the small business provisions came, subchapter 5 small business provisions came into effect at the beginning or the end of February of this year, there's been an uptick in those chapter 11 cases. Some of it was parties waiting until that new statute came into effect, but then even since the CARES Act went into place, there's been several more businesses filed subchapter 5 cases that wouldn't otherwise have qualified prior to that act. The CARES Act also provides for stimulus checks to be sent to individuals, and there's provisions in that act for how those stimulus checks will be treated, especially in a Chapter 13 case where that individual is working and is repaying their debts over time. That stimulus check from the government is protected in certain fashions from turnover to creditors in those cases. Additionally, the unemployment benefits that you may qualify for under the Family First Act may also be protected in the Chapter 13 context from application to your Chapter 13 plan. The Federal Reserve also recently announced what are being called bridge loans that the Federal Reserve may be making. These are loans generally for a 4-year period. They are loans that can be paid to larger businesses than the PPP loans would be applied to, and over a slightly longer period of time, so 4-year repayment period rather than the 2 years under the PPP loans. The guidance I've seen on the Federal Reserve bridge loans is that they are not available for bankruptcy debtors. So if you're already in a Chapter 11 plan or a Chapter 11 case, you haven't got your plan confirmed, that sort of loan would not be something that you would otherwise qualify for. Additionally, no matter what type of loan it is, in a bankruptcy context, if you're already a bankruptcy debtor when you are applying for and receiving those loan funds, that loan is something that would generally require bankruptcy court approval to obtain. The court, as your new business partner, would need to approve any additional debt that company is taking on. I think in the context of PPP loans, those are potentially fully forgivable, 100% guaranteed by the SBA. I don't anticipate there would be much problem getting court approval of that sort of loan. If you're looking at a different sort of borrowing, for instance, the economic injury disaster loans that the SBA administers, those are loans that you would otherwise qualify for as a Chapter 11 debtor, but those are the types of loans that would still require court approval in order to receive. Those types of loans generally require some sort of collateral, which is always the big issue for a Chapter 11 debtor. A lot of times you already have lenders that have interest in all of your collateral, and so granting an additional lien to the SBA that has a priority above your existing creditors may become an issue in getting that court approval and approval from those other lenders. I'm not saying it can't be done, it's just an additional hurdle that has to be surpassed. Generally speaking, I think there's a lot of fear and reticence to discuss bankruptcy in the context of trying to keep my business going. And I think that's a mistake. I think as far as businesses go, especially in the current climate with COVID-19 and the virus, there's some things you can do to plan for your business, plan to keep your business alive. One of the first is stay on top of the assistance that's out there. The PPP loans, for instance, are basically a free grant from the federal government if you can jump through the hoops and get the forgiveness applied. There's no reason why a business shouldn't be applying for those things if they qualify for. The legislative changes are happening on at least a weekly basis, if not a daily basis in some cases. Additionally, the lenders themselves are getting creative and coming up with programs to help protect those businesses. I have a banker, a friend of mine, who's fond of saying, look, as a bank, I don't want the collateral back. I want to be paid. I want the money back. And so there's many banks that are coming up with ways and programs to assist their borrowers, especially in times like this. So be aware of those. Don't be afraid to ask for them. Use those programs, use the government programs that are out there to assist your business and to assist you in keeping that business going. Another thing to remember, business debts are not necessarily your personal debts. So unless you have a personal guarantee of something, your business should be a separate entity, and a separate entity with separate debts. Many times we have clients come in that have cashed out their entire retirement programs to try and keep their business afloat, which isn't necessarily something that you would need to do, especially in today's climate with some of the assistance programs. So keep in mind the separateness of those debts. The other problem that a lot of times we will see with bankruptcy clients that come in is that they want to use bankruptcy as look, this is my final last ditch. I have no other option. This is the final straw, right? But having it be your final ditch option doesn't mean it needs to be your last minute option. A lot of times clients come in and they've waited so long to consult with an attorney, to consult with their accountants, to consult with anybody about the different options that they have, that they've limited their options simply because they waited too long. It may be a company that could 100% be reorganized and repay all of their debts, but they've waited so long to seek advice that they've missed so many windows of opportunity and really don't have any opportunities left. So the time to consult with your accountant or your attorney or a financial advisor or someone at least is when you first start feeling the press, the business press, when you're having trouble paying the mortgage the first time, when you're having trouble paying suppliers, that's when you should be seeking that advice and actively or proactively planning for your company to stay afloat. If you've gotten to the point where you've cashed out your personal retirement to fund the business, you've taken loans from the business loan sharks that are now pulling daily amounts out of your bank accounts, you've waited too long. In many cases, there's not a lot that the bankruptcy code will do to help your business at that point. As the virus continues, hopefully it ends soon. I think everybody is hoping and praying for that. But if it continues, now is the time to be proactively planning for your business. If that includes some sort of restructure through bankruptcy, great. If it doesn't, great. If your business can stay afloat with just some conversations with my lender and working with that person and getting a couple of months reprieve from a loan payment, great, do it. If your business needs to reorganize its governing structure, there's partners that have really left, and we haven't really ever documented that. Now's the time to get some of those things cleaned up. So it's a good moment to sort of sit back and look at your business and make sure that it's best organized for proceeding forward. Hopefully this has been helpful. Like I said, there's some future classes that we will be teaching moving forward. If you're interested in those, watch the social media platforms. That's where sign-up information is generally found. If you can't see those anywhere, you can always email our marketing coordinator, Kyla, Kyla, at angstman.com, and she can get you signed up for any of those moving forward. I appreciate you chiming in today. Hope you all have a good week. Thank you.